Arturo, we listen you.
Hi, Judy. Thank you. I don't know if you hear me so good. Everybody can hear me? All be fine.
Yes.
Yes, Carlos, very
Okay.
well. Carlos, gracias.
Thank you. Thank you. Welcome to our second Partners Conference online to UC&CS. Bienvenido a nuestra segunda conferencia de socios online de UC&CS America. The topic today is a lot of outsourcing in the world, prepared by the committee legal work around the president. El tema de hoy va a ser el outsourcing laboral en el mundo. Fue preparado por el comité legal de UC&CS Global, el cual tengo el gusto de presidir. ¿Okay? Como ya lo indicó Judith, nuestro primer participante va a ser el abogado Mendelsat de Sudáfrica. Now Judith indicates our first expositor is the lawyer Mendelsat from South Africa. Welcome, Mr. Mendel. Welcome
Thank you very much.
Africa for UC&CS. And
Yeah, the internet's a bit unstable here, so hopefully you can all hear me.
yes, we hear you very well, Mr. Mendel. Mr. Mendel.
Thank you. Thank you for the welcome.
Ahead. All yours.
Thank you. Yeah, so I've been asked to speak about labor outsourcing in a South African context. I'm not sure. I sent through a PowerPoint presentation to be put up whilst I speak and to be shared with participants. But if it's not possible to share it at this point in time, that's also fine. I'll just speak. What I want to focus on first is just a general overview, kind of a non-legal, more commercial overview of labor outsourcing in South Africa. And then from a legal perspective, being a lawyer, of course, I want to speak on one major risk that clients on the one hand, but more often suppliers of the outsourcing service, what risk, a major risk that confronts them should they participate in outsourcing arrangements in South Africa. Now we know what obviously outsourcing is and what it means. The performance of a service is either being done internally or by others. Obviously, it's now done by an external service provider, or a existing service provider is replaced by a new service provider. And where the risk arises for clients in this regard is where the outsourcing part and parcel involves either the handing over or transferring of assets, or the handing over transfer of employees, or intangible asset, be it through ownership, be it through use. That's where a risk attaches and a risk arises for clients. Starting off at a basic premise on the regulatory environment, South Africa doesn't have any national laws that regulates outsourcing. So it doesn't prescribe how outsourcing can take place. It doesn't place constraints, particularly on the private sector, in how it can outsource services to a supplier of services. But that general proposition, of course, like most general propositions have some exceptions. The one exception is where you are contracting in the public sector with government either at a national or a provincial or a local municipality level. There are certain acts of parliament, such as the Public Finance Management Act, the Municipal Management Act, and other pieces of legislation that regulate tender processes and bid evaluations. And there is a very complex matrix of rules that would prescribe how an outsourcing procedure would work. Of course, it's beyond the scope of this talk to go into that in any detail, but be aware that if you want to contract with any kind of government body, that you would need to get regulatory advice as to how you would contract in South Africa. Specific regulations, particularly in the finance sector, to the extent that any outsourcing would be taking place there, particularly in the outsourcing of IT services, etc. That's the one exception. And then, like I said, there is a major risk for potential clients and the suppliers of services in South Africa to clients, in that a particular section of our Labor Relations Act called Section 197 becomes applicable, where Section 197 deals with the transfer of a business or a portion of a business as a going concern. And that definition, which is fairly broad, can capture an outsourcing arrangement, be it an initial outsourcing, where for example, a university had people in its employ who cut the grass and landscape gardens. One of the most popular cases on the subject deals with a university in Cape Town, with the outsourcing of a service like that, or where that service has been outsourced for any number of years already, and the service provider is replaced by a new service provider. That, as one commonly called a second generation outsourcing, or third or fourth or fifth generation outsourcing even, can also fall within the ambit of Section 197, as that outsourcing could tick the relevant boxes for it to amount to a transfer of a business or a portion of a business as a going concern. And important to know that in the definition of business, it includes a service. So the outsourcing of a service can amount to a transfer of a business as a going concern. There's no regulatory prescription there, but what it does do is attach certain consequences to an outsourcing which amounts to a transfer of a business, and we'll get to that soon. From a commercial arrangements perspective, generally one of three commercial formats or commercial forms are used. More often than not, you have a single supplier outsourcing, where it's simply a client outsourcing a service to a supplier. That supplier may subcontract a portion of that service to a third party, but generally it's a bilateral, bi-party arrangement, two-party arrangement. Then you can also have a multiple vendor outsourcing, where the client outsources to any number of different vendors. They each have their own responsibilities and accountabilities, but they conclude separate agreements. And then, which you're seeing more of these days, the third option is where a joint venture is actually concluded between a client and a supplier. A separate company is formed. The client, who is outsourcing the service to the supplier, actually has some kind of control and input into the joint venture that runs the business or provides the service, so that it has control and input into the level of service and how good or badly the service is being provided to it. So that's an interesting opportunity for the client to actually have a bigger say in the business that provides the service. Like I said, the types of outsourcing we see in South Africa, they're either the initial outsourcing or a second or later generation outsourcing, where a service provider is replaced. Now, why this is important, particularly for a supplier, because often suppliers go in, they tender, put in a bid to take over a service from a client. Let's say a university invites bidders to cut their grass. The supplier works out the costing model, how much they're going to charge the client to do that service. They understand, or they formulate their own plans on what they're going to be doing. And then suddenly the workers who are employed in the positions that are being outsourced, or were providing the service that's being outsourced in the employ of the university or in existing or current service provider, suddenly says to the new service provider, we are transferring to your employee. Section 197 of the Labor Relations Act applies, and then a court case ensues, and the labor court has to decide whether or not that outsourcing transaction falls within the ambit of Section 197. Does it amount to a transfer of a business or a portion of a business or a service, and is it a going concern? And when those three boxes are ticked, then the outsourcing arrangement attracts the consequences of Section 197. What are those consequences? One, and we'll speak about the old employer and the new employer. And if we just keep it simple to the client who's outsourced for the first time, the client being the old employer, the supplier being the new employer, the new employer automatically steps into the shoes of the old employer for the purposes of all contracts, particularly the employment contracts. What that then means is that the rights and obligations in existence between the employees of the old employer at the time of the outsourcing now transfer to the supplier, and the supplier therefore is tied contractually to those employees in respect of those rights and obligations. Also,
Excuse me,
anything that has been done by the old
Mendel, excuse me, can you hear me,
Yes.
please? Yeah.
I can.
Are you going to present material, or would you like us to share it with you? Your PowerPoint, would you like to share it?
It's fine. It's fine. I can. It might be quicker because I think it's quite time sensitive. I'll just speak, and you can share the material with everyone afterwards, and people can go through my slides. I'll just speak. I'll speak now. I think it'll delay us if we put the slideshow up.
Okay. Thank you.
Okay. So anything done before the transfer is deemed to have been by the old employer is deemed to have been done by the new employer, and the employees who transfer as a consequence of 197, they transfer with their full service history intact with the old employer, so they don't. So, for example, if there are going to be retrenchments later, the severance pay is not calculated, which this outsourcing took place. It's calculated from the date on which that employee started with the old employer. So it's a very deep grave there for a potential supplier if they think that 197 doesn't apply and it's not a transfer of a business and a going concern, but the court simply says that it is. And therefore, if you are going to enter into an outsourcing arrangement in South Africa, either if you are the client outsourcing to a supplier, or more importantly, if you're the supplier taking on that service from a client, it is vitally important that you get legal advice from a reputable firm in South Africa to advise you on whether Section 197 is applicable or not, and whether the consequences of 197 will apply to your outsourcing. Because the employees who transfer as an automatic consequence, it's by operation of law, so the parties can't choose whether or not 197 applies. It applies legally and factually, or it doesn't, and a court will decide that. When those employees transfer on terms, they enter the employer of the new employer on the same terms and conditions that they had by the old employer. So, for example, the same pay. The new employer can't pay those transferring employees what they were earning, what their current employees earn. So you cannot. The transfer is on terms and conditions that are on the whole not less favorable. And again, it could be a half an hour talk on what it means in South African law, on the whole not less favorable, but for present purposes, assume that it's got to be on the same wages, on the same leave entitlements, all the basic conditions and contractual rights and obligations are the same. So then we get to when does Section 197 apply, and what must we look out for? What should set the alarm bell? Looking to enter into an outsourcing arrangement in South Africa, because it is a labor legislation that's applicable. In South Africa, there's a great emphasis on continuity and security of employment. So workers have many rights, statutory rights in South Africa, and the purpose of 197 is to ensure that there's a continuity of employment. People do not lose their jobs when there is an outsourcing. The determination of whether it applies is very fact and circumstance specific. Our courts follow a substance over form approach, so even the contract do their best to formulate the contracts in such a way that it doesn't look like a transfer of a business as a concern. The court will still interrogate the facts and see whether or not factually was a transfer of a business as a going concern or not. The outsourcing, like I said, the outsourcing or change in supplier can trigger Section 197, and the generation of the outsourcing doesn't make a difference. So you could have a first generation outsourcing they went to a Section 197, have a second generation outsourcing, they didn't amount to a Section 197 transfer, but then in a third generation outsourcing, a new supplier comes on board, it factually takes on certain assets or gains the right of use or takes over certain contracts or takes over a certain amount of employees, and that triggers the application of 197. So every transaction needs to be looked at on its own. The first requirement, so just again, the three requirements: was it a transfer? Was a business transferred? And was that business transferred as a going concern? Transfer, business, going concern. Transfer is an easy one. That's simply whether something has changed hands. The mechanism isn't too significant. How the parties have contracted the transfer isn't too significant. The two things that are often the area of contestation and where the fight occurs in court is whether what has been transferred amounts to a business or an economic entity. And secondly, whether that thing is a going concern. On whether it is a business or an economic entity, one has to look at the various components that constitute a business and whether they are relevant to the particular transaction. So is there an exchange or transfer or a handing over of movable and fixed assets? Is there goodwill that's being exchanged? Is there a workforce? Are there employees who are moving in terms of the arrangement? Are there contracts that are being exchanged between the parties where the supplier steps into the shoes of the old employer for the purposes of for the purpose of providing the service, and whether the activity that's being performed is still the same. For the entity that is being transferred to then amount to a business, some or all of those factors must be present, but it's not just sufficient for there to be these separate components. The components and those who practice in law in Europe and who deal with the kind of 2P regulations and have dealt with these matters in jurisdictions in Europe this will sound familiar to you. The components must also be sufficiently linked together to be an identifiable or be identifiable as an entity. So it's not just enough that these components are there. They must be sufficiently connected to each other to be a discernible and identifiable entity, and that's what the courts should look at there. Then going on to the question of a going concern, what do the courts look at to see whether what has moved from the client to the supplier, whether or not that is a going concern? Because if you're simply transferring the service, if the service is simply being taken over, then of course it's not a transfer of a business as a going concern. But if it is the business that provides the service, if it is the business that renders the service, then of course, if that's the thing that is transferring, then the boxes will more likely get ticked that it is a transfer of a business as a going concern. And there what the court does is the court would look at a snapshot. It would take literally a photograph of what the entity looked like on the day of the transfer, then take a picture of what the entity looks like in the hands of the supplier, the day, a week, a month after the transfer, and then compare those two snapshots. And if those two photographs are substantially the same business, or show substantially the same business, but just in different hands, if the identity of the business has been retained, those identifying features are present even though the business has changed hands, then a court is more likely than not going to say that this is a going concern. This thing didn't change substantially when it moved from the client to the supplier. It wasn't just the service that was outsourced, the business was outsourced, the employees moved, certain assets were taken over, certain contracts were taken over by the new supplier, intellectual property changed hands, and those would be things indicating that the outsourcing of the service actually amounts to the transfer of a business as a going concern, and it's substantially the same business or service now in the hands of the supplier. So I think I've been on for 16 minutes. I've been told it's 15 at most. if I then just can wrap up, in conclusion, it's important to know, of course, that not every outsourcing or change of service provider triggers Section 197. On balance, most don't, but many of them do, and it's important to be on the lookout for that. It's not important. It's irrelevant what the client and the supplier calls it between them. They might do their best to name it or structure the commercial arrangements in such a way so that it doesn't look like a business or a portion of a business as a going concern has been transferred. But it is a substance over form approach. The court will interrogate the substance of the transaction. It will look to see whether the three requirements are present, and it will be a fact or circumstance specific inquiry. And one outsourcing might be a transfer of a business as a going concern, and another outsourcing might not. It all depends on the facts, and every single individual transaction, a proper due diligence should be done, particularly by the supplier, to make sure that it is not confronted with consequences that it didn't factor into its plans when it tendered or bid for the contract with the client. So that's from my side in 15 minutes, an overview of outsourcing in South Africa, and what the potential major legal risk is for particularly suppliers to look out for when they are trying to win outsourcing contracts, and also for clients to look out for who are trying to outsource, to make sure that they're aware of whether or not Section 197 applies to the proposed transaction. Thank you.
Thank you, Mr. Mendels, Sas. Now we have more clear how be the outsourcing, the labor outsourcing in South Africa. Have some question. I think I read Teodoro Trago, the lawyer from Venezuela. You have any question for Mr. Sas, Teodoro?
Not right now. It was very clear. Thank you.
Okay, thank you, Teo. I read you some comments. Okay, Mr. Sas, thank you for your exposition. It's very, very clear to me. I think to all the lawyer of the Legal Worldwide Committee, be so clear when this position. Welcome to UC. Okay, you tell me now you need 3 minutes to change the connections. Send the certificate. And after
thank you very much, Mendoza, for your brilliant participation, and it was nice to meet you. Of this moment, yes, excuse me?
I said, thank you, gracias.
You're welcome. De nada. Of this moment, we are going to change the transmission, and we will do it in Spanish. Those who wish to listen to it in English, you can do it to YouTube channel UC&CS Global in English, and who wish to listen in Spanish, you can do it by channel and YouTube UC&CS America, or by Facebook Live en Spanish and Webex en Spanish. Entonces,
y pueden usar la opción de subtítulos también,
también pueden usar la opción de subtítulos. Necesitamos 3 minutos para poder hacer el cambio de esta señal, pero a partir de este momento vamos a pedir a Francisco Betancourt si se encuentra conectado aún.
Hola, sí estoy aquí conectado.
Muchísimas gracias. Bueno, pues,
to honor us in granting the certificates to the speakers. Just give me 1 sec. So In order to make this change in the wires to broadcast in the different languages, so please give us some minutes. So bear with us 2 or 3 minutes to project the diplomas. I think the change is already made, so you will be able to listen through the different channels in Webex, Facebook Live. You will be listening in Spanish and in YouTube, UC&CS America in Spanish, and in YouTube, UC&CS Global in English. Again, thank you very much to all the participants. And then we urge you to make questions, doubts, comments in the chat of Webex or in the different platforms through which we are broadcasting. So Francisco Betancourt, thank you very much. We will share the diplomas. Okay. So we will grant them in English, right? In English, they will be granted in English? That's the question, or in Spanish? In English, because all the participants were English speaking. So, muchas gracias por la participación de Sherry Mejelba. No sé si siga conectado, pero quisiéramos otorgar el presente diploma por su participación valiosa como panelista de nuestras conferencias técnicas 2021 dentro de la 22ª Junta Congreso Anual de Socios de la Firma Mundial con el tema Haciendo Negocios en Egipto. Esto se llevó a cabo el 28 de septiembre de 2021 vía Webex durante 1 hora. Muchas gracias, Sherry Melba, y muchas gracias por su participación. Este es el diploma para usted y fue esta información sumamente interesante. Thank you very much. Next, we will share the next diploma. Sherry, I think, is not connected, but we will forward him his diploma. Well, just tell me, Judith, when we will resume. Thank you very much for your understanding. Well, el siguiente diploma se otorga a CPA Miguel Aguirre. Muchas gracias por su participación. Como siempre, es un placer escucharlo. Y este diploma se otorga por su valiosa participación como expositor en los ciclos de conferencias técnicas 2021 dentro de la 22ª Junta Anual de Socios con el tema Haciendo Negocios en Uruguay, impartido el 28 de septiembre del 2021. Muchísimas gracias, Miguel. No sé si siga conectado, pero su participación fue sumamente importante. Muchísimas gracias, Francisco. Fue un placer para mí exponer este tema y les agradezco por darme esta oportunidad. Gracias otra vez, Miguel.
Continuaremos con nuestra reunión de UC&CS. Finalmente, el contador Jeffrey Chang queremos darle su diploma de participación por su participación brillante como panelista en la conferencia técnica 2021. En la reunión de UC&CS Global en relación a su tema Doing Business in China and Hong Kong. Muchas gracias, Jeffrey, por su participación. Muy interesante, muy importante conocer la opinión de un especialista en China sobre los asuntos más importantes que están ocurriendo allá. No sé si aún esté conectado, pero apreciamos mucho su participación. Muchas gracias, ha sido un placer para mí. Vamos a continuar. Judith, Mauricio, muchas gracias por su tiempo. Para mí también ha sido un placer participar en esta reunión y como puedo ver, también hay un diploma para mí. If you allow me, I would like to make the handout of this participation. Juan Santiago Betacur Santiana for his participation as speaker in the conference cycles and conferences 2021 in the 22nd meeting of yearly Congress of Partners with the topic panel Doing Business After COVID-19, given on September 28, 1 hour, signed by Mauricio Movara Gonzalez by UC&CS Americas USC. Thank you very much, Mr. Betancourt. Thank you. Thanks to you. My pleasure to participate with UC&CS Global and my pleasure to participate with foreign partners. My pleasure to hear about the different opinions and cultures of other countries. Let's continue with this talk, and I hope it has been pleasant for you. Now, let's continue with the panel that we were at. Now, let's give the floor to Carlos Castro, Venezuela. Go ahead. You can continue with this great panel as well. Thank you, Judith. Let's continue then. The next panel was Aquilino Perez. He notified us that he had a hospital emergency for his father. I hope this is not a big concern, and I hope that everything is with your father. So we will be attentive for news. We are with you. Next speaker, it's going to be Seila Guevara from Peru. Seila entered to the Liga World Committee. We thank for that, and we welcome her to UC&CS Global. So go ahead, Sheila. Thank you, Carlos. My greetings to all the attendees. Could you help me sharing the presentation, or shall I do that? They're going to help you with your presentation. Hold on a second, please. Preliminary, I would like to mention that we have this figure of labor outsourcing regulated. We have two figures regarding outsourcing and non-direct hiring of workers, not a direct one, which is labor relationship between a company and a worker, but also by contracting specialized companies. That's the outsourcing topic right now. Next, please. I was precisely saying that in our country there are two modalities, direct hiring and the one that I was making reference. This is the classical relationship of work. That's when you hire a worker, could be for a labor contract or subject to any modality which is a fixed term. We have different modalities. Each one has its own features. And there's also a semi-laboral or labor contracting. This means the following. This means that it is for students, practitioners, interns, or recently graduated in the work. And why it says semi-laboral? Because there are contracts with universities and institutes and companies, so one intern can render services or make its practices with some benefits regulated by a standard. So it is not for free. They do receive some benefits. That's why we call it semi-labor. And that's what we're going to be hearing. Outsourcing, non-direct hiring, when a company is doing this contracting by means of a third party. We have two regulated, that's a third party, or intermediary. That means hiring a cooperative of workers with complementary or specialized services. And then we have outsourcing, when you hire a company that is providing third-party services. Next, please. Thank you. So let's start with intermediation in labor. What does that mean with this figure, which is regulated in Peru? This is labor provision. A company is hiring one company to render labor. They need a worker to work in the company, and I am going to give you an economic retribution to you, third party, and you are going to help me with that. To understand this labor intermediation, we need to understand also the definition of three activities: the main activity, the complementary activity, and the specialization. The main one is the main business process, services, rendering, exploration, transformation, organization, etc. The main activity, because without it, the main activity of the business cannot be carried out. Or if we stop doing it, it would be interrupted. And the other one is auxiliary of support, and its absence is not going to interrupt the flow of this activity, like messenger. Also specialization activities, but they need a scientific or specialized services. For example, maintenance, sanitation. Then, taking into account that labor intermediation is just labor provision, and having these three definitions in mind, when is it going to be permitted? It is permitted only for major activities, but only in two assumptions. In the assumption of a contract that is of supplement. For example, I have a worker that will have a maternity leave, or it's going to be in holiday. I need a company, a specialized company, doing this labor intermediation to give me an alternate worker during this maternity leave. And this can be carried out as the main activity of the company, or probably also a temporary contract. In Peru, also, this is a transient activity. So only in these two assumptions, we cannot have labor intermediation just as any other worker in the main activities, only in these two assumptions, which is occasional and a temporary fact. And this is done in a more flexible manner in complementary activities. I can hire surveillance, cleaning, and courier services, so I can have some workers providing this service, because it is a complementary activity, not the main one. And also for specialized a company to provide maintenance and also sanitation. So only in these three cases we can have this labor. Next, please. This labor intermediation is subject to formality. It is not that a company says, I am going to provide labor intermediation and this is it, and then I am just rendering labor. You need authorizations and permits. So you need to comply with some requirements like social capitals and some permits. If it is cleaning, you are going to need specialized services and permits. And based on these requirements, the Labor Ministry will provide you with the authorization so you can provide your services in a temporary manner. This permit is not indefinite, it's yearly. So you need to be renovating these services to hire with your customers. There are also some services that need bonds. That's for labor obligations for some workers. And these rights of workers mean that those that are in this user company, which is the main company, will have the same rights than the major company. So in this size, you're regulating labor intermediation. Next slide, please. An important factor here when you are talking about third parties could be solidarity responsibility. Users are not going to be saying, as I hired a company and you come here with your workers, then I am going to pay you, and if there's any labor contingency, I am not responsible. No, solidarity responsibility is by law. So if there is any contingency, a labor contingency with intermediation services, the main company, the user, is going to be solidarily or in solidum responsible along with the employer. This responsibility is by law and has a 3-year period from the cessation of the displaced worker. And then we also have third-party outsourcing. In Peru, there are specific laws that regulate these services. Regarding this definition, this is given by the regulation, pointing out that we understand these third-party companies, the development of companies with some requirements and some features. These requirements imposed by the same company is that they will assume these services, and they're looking to have a real company, not a facade. We do not want labor intermediation, but a company that can assume by its account and risk rendered services. Also a company with its own technical resources, that is not only constituting a company and then having the permit and saying that you can provide services. You need to have computers, and depending on the services, you need to have your own material, furniture, and probably vehicles. If I am only going to constitute a company and the main company is going to render or work implements, in this case, you are not fulfilling with that major requirement, because each one of them makes up to come to third-party hiring, and they should be responsible of results. Workers should also be subordinated to this company. In many cases, when you do this in service, third-party contracting, the worker goes to the major company, and then the boss, the supervisor, is the one that directs the activities, and then the employer is a third party to provide this, and then the boss is in the company. So these requirements are being analyzed one on one to determine whether it is a real third party outsourcing. Then there are certain features in addition to the requirements. This also provides for some other characteristics to determine whether this is a third-party contracting. They should have a plurality of customers. If I am the only customer and I am just having one customer, this is indicating of something weird. So we need to assess requirements and also the modality. Could be some instances in which there are not many companies providing the services, so probably it is the one in the market, and that could justify that it is the only one. But this is a characteristic to determine if this third-party contracting is real and that they have their own equipment. They should have property of their own. Or also in administration could be the use that they hire this good, but they should have this element, and this is a requirement to have their own resources. Capital investment, that is that this should be an comprehensive payment for this service and not individualized payment per each worker, saying that this worker is this amount and your company compensation is 5%. No, that has to be global, because this is a complete logistics service. I am not contracting operators. This is part of the retribution, and this has to be shown in the contract that this is the service and not only one person. And no permits are given for that case. So in which assumption you can have services in third parties like managerial services, third party contracting for external works services. We also have contracting a company that has a comprehensive service. Next slide, please. Labor intermediation, this is also subject to denaturalization. When do you do that? This is going to be denaturalized when you analyze the requirements and you have these characteristics, and then you can determine that this hiring for a third company to provide a comprehensive service is non-existent because probably the worker is subordinated to the main company, and this company has no equipment. It is provided by the main country, the furniture and all the instruments are of the main company. So you can be demonstrating that there are no customers. I am the sole customer. And this demonstrates that the truth, this is not outsourcing, but it is just an intermediary, and labor intermediary is not permitted for these major activities. Therefore, then you have the denaturalization, which is the sanction that the worker will become subordinated of the major company and not the third party in this case. As it is pointed out, this is one of the causes when the workers are subordinated to the major company. This is very common because in the day-to-day activities, when they are in another company, it is very complicated that they work in the coordination of this worker, of the main company and the third party. And you can see this in contracts. You can see that there's autonomy, but in day after day activities, it is generally the main company supervising and directing this work. And you need to take care of these because these elements are the ones that lead to labor contingency. So they want to be considered as employees of these companies due to this consideration. And the main part is the worker who's displaced, judicial processes, and everything is a cost analysis. It is not that the sole customer is this company. There has to be a reasonable analysis. So if we go to courts, we can analyze this, and based on this, we can determine if it is a real or not contracting, and with the case analysis. And also, maybe superintendent fiscalizing all these intermediation and third parties, and they are going to verify either by the accusation of the worker or by law. They will verify works contracts intermediation to see whether they comply with the requirements. Otherwise, we will have sanctions and some fines at administrative level, and this is independently from the judicial system. And we also have solid responsibility in the case of services. You can see this in the solidarity responsibility differently. From this, it's for 4 years from the cessation onwards between the intermediation and the user in this third-party hiring, and the solidarity is for 1 year. Therefore, the employer does have the responsibility to answer for 4 years. So more or less, this is in brief words the figure to regulate in Peru outsourcing this third party, but as it has some elements which are also regulated, and we see this labor intermediation, so there's a vision on how to regulate this hiring by third parties when I am not contracting directly the worker with a work contract. So that would be in my part. Thank you very much, Sheila. Your presentation was very clear, and certainly the legal way of having outsourcing in Peru would be by means of complying with controls and laws established by the law for those activities that are permitted. I would like to know if there is any question for Sheila Guevara regarding her presentation. Sorry. I do have one. Okay, very good. Yes, we can hear you, Pedro, very well. Thank you, Sheila, for your presentation. It is interesting for me that every time I had a question, in your next slide, I had a question. The only question that I have here, you said that in the event of intermediation, there was an obligation of paying the same salary of the user company. In the case of third party, is that also possible? Do we have to respect the same services presented by the third party? There's some flexibility here because this specific standard is not pointed out. What we have there is that the third party company will pay for the benefits but not a warranty that they should win or earn the same as the other. We should undertake a comparison, and this is a third-party activity. Therefore, this company has some autonomy to establish salaries. Thank you very much. Thank you, Sheila. A very good answer. Therefore, we're going to see our next speaker. Our next speaker, Theodore Vitrao, lawyer, partner of our firm in Venezuela, Castro Perez and Associates. He's going to present the evolution of our labor status, what we call in Venezuela tercerización or outsourcing. Good morning to all of you. It is my pleasure to talk about this. Probably, Judith, can you help me with this presentation? You can share it. Just put share. Let me see. I'm going to try to do it. Yes, I'm going to try to do this. I don't see how to share it. I'm sorry. Don't worry, we're going to share it for you. Yes, please help me. Good afternoon to all of you. I'm going to present outsourcing in Venezuela. My name is Teodoro Itriago. We need to understand this historical moment when this labor law was enacted. Next slide, please. In 2012, the new labor law was enacted called the Law for Workers. And this is a famous name at worldwide level. And this was in compliance with a transitory law that was enacted before, and here it forced to have a reform in this law. This law was fostered by Hugo Chavez, that was a leftist government pretending that workers' rights were never protected. So he established a very controversial law and a supposedly revindication of workers' right. As An important part in the 90s, when we had this new regime in Venezuela, there was a privatization of several key companies in the state, and many of these public companies had collective contracts that were really costly. So they started to use outsourcing and third party contracting to use these collective work contracts, making these operations more economical or feasible. Before this new change, the law reform, labor law was radical. And now, talking about outsourcing, we used this terminology in a negative fashion.
So, the meaning in Spanish, the outsourcing is just to ask another person to do something for your company, but the outsourcing was defined as a fraud or as the way of not respecting the rights of the employees. So in our article in a piece of land, I don't know if you can help me to share the screen. Okay, Adrian, can you help Teodoro to share the presentation? Okay, so it was defined in the law like the outsourcing as a fraudulent act performed by an individual or entity to violate the rights of employees. The outsourcing term has a negative connotation. It is a prohibited figure by the law because it is understood that the only thing that it seeks is to violate the rights of employees. And this is how it was established a global provision. The 47 and 48 established, if we can go to the next slide. Yes, I would like to move 2 or 3 slides where the legal definition appears. There. Okay, Article 47 establishes that outsourcing is a fraud and therefore it is prohibited. Next one, in Article 48, it establishes what are the conducts when outsourcing appears. And this is how we can establish that the hiring of any employees to provide services that are like providing a service or that has to do with the commercial development of the company is fully prohibited because it violates the rights of employees. So any hiring has to exist by respecting all the rights that has to be respected by the end user, which is the company. So can we move 2 slides, please? Judith, could you help me moving 2 slides? One more. One before. Even though we have the contractor figure, which is still accepted in Venezuela, but this is a person that is sub-hired to perform a concrete activity or a service performed by their own means, their own employees, like my colleague said, but it must be for activities that are not the commercial activities of the company that is the beneficiary. So in this sense, in the jurisprudence, or were this kind of subcontracting. And it is understood that the outsourcing of a contractor accepted by law. So can we move one more slide? And in this sense, as a way of example, there are two sentences with similar dates. It's in which, in the both cases, where there's the existence of an outsourcing and the employees are demanding the payment from the company that got the benefits. So in this sense, the determination of outsourcing will depend of the case-by-case analysis. In this case, the law establishes in Venezuela the principle of primacy of facts. In this should be addressed to the facts to determine if there's an evidence of a labor relationship or there's a change in our legislation. The first example was the sentence restaurant. It is a prepaid services clinic and the patients are subscribed, and also the services were provided to the Star Bay, and this was prohibited by law, and the social rule when it comes to medical services and for Rescarven clinics, it was possible to do this, and it was not an outsourcing, it was a simple subcontracting, and consequently there was the beneficiary of the service was Rescarven. Could you move? The second sentence, where this is the case of a company of the cleaning services, the Hoover company, provided to a packaging company. And in this case, it was determined that it was an outsourcing and the employees were fully enjoying the rights of the company. And for this company, it meant that the cleaning of the manufacturing plant was a process that was natural and cost substantial of the commercial development of the company, and therefore could not outsource staff. So the cleaning at the industrial level, if it's a specialized matter, they could be subject to outsourcing. But here, as a consequence, I know that outsourcing in Venezuela, it's only reserved for construction industry matters. But let us remember that in the case of Venezuela, the national industry, because this is just reserved to the state, and therefore there's no lawsuits in the use of outsourcing, because the state-owned company does not incur in these matters. The outsourcing as such, the legal definition is prohibited because the law understands it as a violation to the law. It's only to violate the rights of employers. But there's a contractor figure that is not used as before. If it's a prohibited activity and the jurisprudence has not been strong enough to determine if it's a contracting or an outsourcing, this figure is now longer being used to avoid a contingency that could not be foreseen. The economic increase of the country has reached unsuspected levels. So the cost of payroll in Venezuela is so high that past behaviors like outsourcing and or subcontracting to save money, also the operation could be economically feasible or more attractive, is no longer used, because we're talking about a country where the minimum wage equals $2, and sometimes the cost of payroll is less by the cost of the local of or than internet service. And the cost of payroll made us not to see more cases in which we could have outsourcing of subcontracting, because we have always used subcontracting, that it was to save costs and not to avoid divisions in the company. This is from the standpoint of payroll, or to determine the time cost, because normally the outsourcing or subcontractings have a period of time specific. I remind you that in Venezuela, the hiring of the employee is exceptional. The law says that all the employees have to be hired under a specific period of time, and they cannot be fired. The employees cannot be fired. So if this had a cost of payroll, or that could be compared with that of the region, we could have the creation of new figures to try to be more aligned to the contractor figures. People are not concerned in creating mechanisms that would make contracting possible and normal in our country. Probably we will see some matters about this, because the dollarization in the country had made that is increasing the remuneration. So it is possible that we could see the way in which we start using the permitted hiring in a more frequent basis. But so the commercial need was to try to use the permitted hiring. This is more or less the current status of the outsourcing in Venezuela. For us, is prohibited, is a fraud, and the contractor is used in very specific cases. I would like to reiterate that I hope that this presentation has been useful. Well, thank you very much, Theo, for your brilliant presentation. So interesting of all the evolution of the outsourcing in Venezuela, and especially the jurisprudence. I hope it will be useful to our dear friend Mexico, that they are starting to have an important change